Good morning, honorable members. It is 10 o'clock. I just want to verify who's present in the meeting. We have Honorable Nkosi, Honorable Mikalakis, Honorable Bartlett, Honorable Suleku, Honorable Zandamela, and I saw Mtetwa.
Recording in progress.
Mtetwa. Could be currently 7 members, and I understand other members will join as well. But welcome, honorable members. Gershwin, if I can verify, do we have any apologies?
Morning, Chairperson. Only from the Minister, Chairperson.
From members?
No, Chairperson. No further apologies.
Okay. Okay. No, thank you. Okay, members. I think in terms of our agenda today, we have quite a long agenda, but I don't expect us to take very long in this meeting. We scheduled it for 2 hours, given that petitions will be meeting at 12. But just in terms of our agenda, we are to get a briefing on the draft amendment regulations, which have been submitted in terms of Section 94, subsection 3 of the Legal Practice Act. And thereafter, we would be considering and possibly adopting the budget policy reports for SAPS, IPID, and the CSPS, as well as the report on the Constitutional Court judges, the judges and magistrates' salary remuneration, which we dealt with last week. I think present in our meeting, we also have representatives from representatives and officials from the Legal Practice Council. I think when I hand over to them, I'll request them to introduce themselves. But that being said, our members, we will then get into our first agenda item, which is the briefing on the Legal Practice Act regulations. Let me hand over to, I'm not sure who's leading the delegation, but I understand that, is it Wilma Lowe who's leading this delegation?
That's correct, Chairperson.
Okay. Ms. Lowe, if you could introduce yourself and the rest of your team.
Thank you, Chairperson. I'm Wilma Lowe of Department of Justice's Legislative Development section. I'm the only one of the department attending today that I know of. I don't know of people of the Deputy Minister's office are also present. And I will be doing the presentation. Can I go to share screen now?
But who else is with you from the LPC?
Chair, I'm not sure who of the LPC is here. I wonder if one of their representatives could perhaps introduce them.
Okay, I see Murray.
Thank you very much, Chair.
You also put on your video so we can see you as well. Unless you're having problems with your connectivity. Okay, I see Clement.
Thank you very much, Chairperson and members of Parliament. My name is Clement Marumo Ahai. I am from the LPC. I'm a member of the council, and I'm the chairperson for the Education Committee. I understand that the EO of the council also is in this meeting, Ms. Charity Mzuza. Perhaps maybe she might also want to formally confirm what I've just said. But thank you very much. We are here. We were told that there might be questions that might be directed to us, which we should be able to provide some light on. Thank you very much for the invitation.
Thank you.
Thank you, Chairperson. Good morning. Yes, I'm here. My name is Charity Nzuza, but we are led by our Chairperson of Council, Mrs. Kathleen Lepu, who's also available today. I see her video is also on. And there is also another member of the Education Committee, which is Ms. Christine Konta, who is part of our delegation from the LPC. We also have Ms. Murray Melissa, who's the Senior Manager in Education for the LPC. Thank you, Chairperson.
Okay, thank you very much. Thank you very much for all those introductions. Let me then hand over to Ms. Lowe to take us then through the presentation. Kashwin, is she able to share the screen, or are you going to do that? Or is it Zolani? I'm not sure who's managing this process.
She was able to share this morning, Chair. We'll just find out now.
I have it on my screen now. Can you see it?
Ms.
No.
Lowe,
Am I sharing?
Ms.
No,
Lowe,
Mr.
you just have,
Dixon, am I?
thank you. If you go to share screen, then from share screen, then you choose. That's it. You're almost there. Correct.
Is it on now? Okay. Thank you, Chair. Let me just, okay. All right. The majority of the sections of the Legal Practice Act came into operation in October and November 2018. The Legal Practice Council was then established, and the first regulations were published in August 2018. Section 94(1)(I) of the Act provides for regulations on the practical vocational training requirements for candidate legal practitioners, as contemplated in Section 26(1)(C) of the Act. Section 26 provides for qualifications and practical vocational training. Section 26(1)(A) and B provide for qualifications. Section 26(1)(C) requires a candidate legal practitioner to satisfy all the practical vocational training requirements as prescribed by the Minister. And then prescribed is defined in the Act as prescribed by regulation. And any regulations must, before publication in the Gazette, be tabled in Parliament by the Minister for approval. Current Regulation 6 of the regulations provides for the practical vocational training requirements of candidate attorneys. In terms of Regulation 6(1), a candidate attorney must serve under a training contract for 24 months and complete a program of coursework of 150 hours during or after service under contract, or serve under a contract for 12 months and complete a program of coursework of 400 hours prior to registration of the practical vocational training contract. Regulation 7 of the current regulations provides for the practical vocational training requirements of pupils. Pupils are candidate advocates. In terms of Regulation 7(1), a pupil must serve under a contract for 12 months and complete a program of coursework of 400 hours prior or during service under the practical vocational training contract. And Regulation 7(9) provides for the modules that the program of structured coursework must comprise of. Then there are proposed amendments that were requested by the Legal Practice Council. And some of the motivation provided for the proposed amendments are that The challenge of securing necessary training as well as the inequity in relation to the training have been identified as some of the barriers to entry into the legal profession. The Council takes into account the differences between the attorney's profession and the advocate's profession, and it is proposed that a compulsory uniform practical vocational training program, which must be completed by all candidate legal practitioners, will be implemented. This program will have a dedicated coursework aimed at empowering candidate legal practitioners on different areas of the law and a satisfactory standard of learning. The Council took into consideration the views of all the relevant stakeholders, and the Council also recognises the developments in the legal profession in relation to the fact that the same tertiary education law graduates are being exposed to. Now I will proceed with a discussion of the amendment regulations. Regulation 1 of the amendment regulations defines the regulations. It's a technical provision. Regulation 2 amends the classification of the regulations. It's the index. It is to insert a new regulation 7A, as I will discuss later. Regulation 3 of the amendment regulations amends Regulation 6 of the regulations. That is the regulation that provides for candidate attorneys. Regulation 3A amends Regulation 6.6. Just to effect a small technical amendment, it goes to the periods of previous experience that an attorney must have before he can take a candidate attorney. And it is aligning the period of legal aid attorneys with that of other attorneys. It's a small technical amendment. Regulation 3B deletes sub-regulations 6.10 and 11. Sub-regulation 10 currently lists the modules of the coursework, but this is replaced by the provisions of the new regulation 7A, and sub-regulation 11 is reenacted as the new regulation 7A4. Regulation 4 of the amendment regulations amends Regulation 7 that relates to pupils. Regulation 4A amends Regulation 7.1 that provides for the time periods of vocational training by pupils. And the proposed amendment will enhance access to training, and it allows for flexibility by providing that pupils will then have two options. First option, a 12-month practical vocational training plus 150 hours coursework during or after practical vocational training, or the second option, 400 hours coursework before practical vocational training, plus then the 12-month practical vocational training. Regulation 4B of the amendment regulations amends Regulation 7.5. It affects the small amendments to the period of previous experience that an advocate of legal aid or a legal aid institution must have before they can engage a pupil. It is just similar to the amendment to Regulation 6. It's just to align that period of previous experience of legal aid advocates with that of other advocates. So it's a technical amendment. Then sub-regulation 7.7 currently provides that an advocate may engage one pupil at a time, but this is now increased by Regulation 4C to 2 pupils. And sub-regulation 8 is then consequently also amended just to refer to the 2 pupil limit in a cross-reference. Regulation 4E deletes sub-regulations 9 and 10. Sub-regulation 9 lists the modules of the coursework, and it is replaced by the new regulation 7A. Sub-regulation 10 is reenacted by the new regulation 7A4. Regulation 5 of the amendment regulations inserts a new regulation 7A in the regulations to provide for a uniform program of structured coursework. This means that the structured coursework of candidate attorneys and pupils will be the same. The modules are listed in regulation 7A2. 7A3 provides that the council may determine the content, and it may also determine what must be in face-to-face instruction, e-learning, digital learning, distance learning, or a combination of these. And these are all measures to enhance access to training. Regulation 6 is only the general provision that the regulations will come into operation on date of publication in the Gazette. The department invited comment from stakeholders on the proposed amendments, and the presidency exempted the department from conducting a SAPS. Thank you.
Thank you very much, Ms. Lowe. As presented, honourable members, these are regulations that deal with the vocational education and training of advocates and attorneys. They were tabled by the Minister of Justice in Parliament in April this year. And in terms of Section 94, subsection 3 of the Legal Practice Act 28 of 2014, these regulations before publication in a Gazette requires the approval of by Parliament, and in essence, obviously the recommendation from this committee would also be to approve the regulations. Honourable members, are there any questions for clarity and or comments that you would want to raise in relation to the presentation? Please indicate by raising your hand. If you're unable to do so, you may also just request to raise any question. Okay, I'm not seeing any hands, honourable members. I want to take it that you are sufficiently clarified. Honourable Dodovo.
Yes, Honourable Chair, thank you very much for the opportunity. If you allow me, just welcome the amendments and the proposals that are made by the Department of Justice. Just my one question, in the overall, is there any recognition of prior learning that is likely to be inserted in the legislation or in the regulations? That's my only point in relation to the modules that were spelled out. What is it that needs to be done at a particular point in time? And that in terms of the recognition of prior learning, is there any recognition or anything that the department will take into consideration? Thank you very much.
Thank you, Honourable Dodovo. I still don't see any other member. Maybe I just, from my side, I have perhaps two issues. And I think the one is more around when you spoke about inequity in training that you referred to in slide 6. If you can maybe provide more context to that. And I think also you indicate that you invited comments in terms of these regulations. How widely were the regulations published, and also provide an overview of who made comments and whether there were any major concerns raised in the comments that were made. Yeah, I think with that, let me then hand over to Ms. Lowe. And I think, and representatives from the Legal Practice Council, if you have one to respond as well. I think let me start with the Legal Practice Council, and then we can go to Ms. Lowe.
Thank you very much, Chair. It's Clement Marumwahai here. And I have quite a bad connection. May I kindly ask not to put the camera on so that I can be audible and so you can hear me properly. Thank you. Thank you very much, Chair. Let me start with the question of prior learning that was raised. It is really important to one understand in what context can one really recognize prior learning, because with these regulations, we are dealing with people who are coming from university. And one would think that the prior learning that one would consider here would be the degree that the candidate, irrespective of their age, and of course, maybe irrespective of when the degree was attained. But that would be the kind of prior learning that one will take into account. But in relation to the structured coursework, it is more about trying to bridge the gap between the university and practice and come up with a structured program that will enable all these practitioners or all these candidate legal practitioners to be in a position for them to really transcend nicely from being students, as you know them, to practitioners. And then even how these courses have been structured, it is to help them to understand the nuances of practice. It is not a course that has been structured to teach them as they are used to in the university. So when one looks at it that way, then you recognize that everyone who wants to be admitted either as an advocate or an attorney will have to go through this process. In other words, the prior learning that one might have had might not necessarily be in sync with what this particular structured course seeks to achieve. So when one looks at that in that way, one would understand that every legal practitioner or every person who aspires to be a legal practitioner, it's important for them to go through this process and to ensure that by the time they are practicing, at least they have an idea as to what practice requires. I'm not sure if I'm answering that question, or perhaps maybe to allow the member to make a follow-up if perhaps I was not as clear. And of course, I mean, I can allow my colleagues as well to come in if they so wish on this question. Chair?
Yeah, I'm here. I'm not sure if there's anybody else from the LPC. Matt, Christine?
Thank you, Chair. I thought the question that you asked around the responses should best be answered by the EO because they processed it. We participated as an education committee in that, but she would be more up to date and be able to inform you the nature because she compiled this and made a submission to the Department of Justice.
Thank you, Chair. I think that the question was whether the publication, whether we widely publicized the way. Yes, we did. We published it in the Government Gazette, and we also sent it to all the legal practitioners. So I can safely say that we widely publicized the proposed amendment, but we only received 2 comments, which was from the CAPA and Legal Aid. So we assumed that people were happy with the proposed amendments as we only received those 2 comments. Thank you, Chair.
Perhaps before you go, the type of comments that were raised, I think part of my question were if you could also give us an indication on the type of comments that were raised and what were whether there were major concerns that they raised in those comments.
The major concern, Chair, was that the amendment seeks to not appreciate the difference between the attorney and an advocate, and that mostly came from the advocates. But I don't think that was the intention of the amendment. We did say at the beginning of the amendment itself that we do recognize that, but we just want to standardize the training. But it was seen in that comment the comment almost said we almost are doing away with the segregate or with the two different parts of the profession.
Okay, thank you. I note you, ma'am.
Yes. Also, just to follow up on what Ms. Nsuza said, the concern by advocates, as she has said, is that we are through the back door trying to fuse the two professions, and that's not correct, because if you look at the content of the structured coursework, it's basically combining what is currently in Regulation 6 and 7. There is trial advocacy, there's drafting of pleadings, and in terms of just the curriculum, the Legal Practice Council will ensure that in no way will advocates be shortchanged in that sense. And the fact of the matter is, at the current, attorneys have rights of appearance in court. So it's really important that attorneys acquire those skills during the structured coursework of drafting pleadings, trial advocacy. And also one of the motivations behind doing this is to make it easier for candidate legal practitioners to move between the two branches of the professions if they have in the coursework been exposed to all those and they've been assessed on that. So all of this is really designed to ease access to the profession and the movement between the two branches. And in no way will it affect the quality of the instructions gotten by advocates, which, as she says, is the main concern, because in effect, actually, the practical training, that is the normal practical vocational training of advocates, will continue. They will have intensive practical training, so will the attorneys. So the structured course is really 150 hours and the assessment will done. So we took into account that concern, which is why we say it recognizes the differences between the two branches of the profession. Thank you, Chair.
Okay, thank you very much. Ms. Lowe, do you have anything to add from the department side?
Chair, I don't have anything specific to add unless someone has a question or clarification needed.
Okay, no, I don't think there was a question in relation to that, so I just thought you would want to add something. But maybe thank you very much for the responses. On members, do you have any follow-up? Are there any follow-up questions or any additional questions that you would like to ask and or comment that you would like to make? I thought the explanations were relatively clear. If not, I think these regulations are quite important and they do address issues around inequity in training as well as access to the profession. And let me then also take this opportunity to thank representatives from the LPC as well as the representative from the department for coming to make this presentation and clarify us on matters. On members, in the next meeting, we will then deliberate further on the matter and or deal with the report of the committee in relation to these regulations. Thank you, representatives of the LPC and the department. You're welcome to leave the platform if you wish, because we're going to continue with our agenda.
Thank you very much. Thank you very much.
Thank you,
Thank you very much.
Thank you. On members, the next item on our agenda. Okay, I was just waiting for. Okay, the next item on our agenda is the consideration and adoption of the budget policy reports. We'll go through each report individually. Honourable members would have received these reports last week, Thursday. I think we'll start with the report on Department of Police. That's Budget Vote 28. Keshwan, if you can go to the recommendations. Our members, we'll focus largely on the observations and recommendations, and thereafter I'll request if our members have anything to add and or any comment to make to these observations and recommendations, as well as to the rest of the report. I take it that you've been through it. I think in terms of the recommendation on the Department of Police, we're saying that the department should, within 30 days of the adoption of the report by the committee, send a detailed GBV and FC. Keshwan, can we go up to the observations? Okay, our members, I'm going to assume that you've had time to go through the observations. As you can see, they were quite. It's quite lengthy, and I think we took time in terms of trying to put the information into the document. If it's okay with you, we'll then go through the recommendations. 7.1, that the department should, within 30 days of the adoption of the report by the committee, send a detailed GBV and FCS implementation plan. There's the GBVF, implementation plan to the committee. It's GBV, it's gender-based violence and femicide. Gershwin, I think we should just add the femicide bit as well. The 7.2, the department should continue interaction and engagement between members of the committee and provincial commissioners to ensure that provincial matters are addressed by SAPS. 7.3, the department should investigate obtaining its own garages for vehicles, which is independent of Department of Public Works, to ensure that there are sufficient operational vehicles for policing across all provinces. The department should urgently prioritize addressing the backlog of the renewal of firearm licenses. The department should urgently address corruption and take action against those members involved in corrupt activities. Strong and decisive actions by SAPS against corruption will send a strong message to those committing crime within the department and will serve to instill public confidence in the South African Police Service. The department should furnish the committee with the relevant provincial budgets when apportioning has been concluded by provinces, that is after the first quarter. The department should implement a focused strategy to address gangsterism in the Northwest Province, and members welcome the support offered by the National Commissioner to the Provincial Commissioner within the province. Members requested that SAPS furnish the committee with a report on the mechanisms that will be employed to address gangsterism and counter corruption within the province within 30 days of the adoption of the report by the committee. The department should consider implementing drone policing as a measure to address high levels of contact crime within the Eastern Cape province and in rural areas generally. This measure may go a long way in addressing the current policing challenges in addressing crime in rural areas. The department should speed up its recovery plan to address the backlogs in DNA testing, particularly as it relates to gender-based violence cases. The DPCI should move swiftly to recruit the required specialists, expertise, and personnel to carry out its cybercrimes and narcotics investigation. In conclusion, we encourage the department to find innovative ways to ensure that the important services which it delivers is not compromised significantly due to budget cuts. And the department was encouraged to continue working towards decreasing crime, addressing gangsterism, and working towards the eradication of gender-based violence and femicide. And I think in addition, we said that we, in terms of our oversight work, based on key issues raised in the deliberations, we encourage SAPS to continue to strengthen the relationship between members of the committee and provincial commissioners. Our members, those were the recommendations. Are there any comments and or additions that members would like to make to the report? If you can give an indication. If there are no hands, I take it that you are sufficiently happy with the report. And then if I can get an indication of whether you would want to move for the adoption.
We are happy with the report, Chair.
Chair, before that,
Okay.
Honorable Dodovo?
I was saying just before that, there is a recommendation that speaks to the fact that the department must ensure that it attend to the issues of gangsterism in the Northwest.
Yes.
I think we were specific in that respect that it is especially in the area of Matrosana where the Deputy Minister Castle Matale even attended. I was just saying that it must capture that, but it must say specifically in that particular area of Matrosana where the rate of gangsterism is very, very high. Thank you. And I support Madam Honorable Bartlett thereafter, Chair, in terms of the secondment to the adoption of the report.
Okay, I think with that amendment made, Honorable Bartlett, we didn't hear you, but I think given the correction, Honorable Dodovo, you're correct. I think the discussion did relate around the area of Mathosana. I think we'll make that correction in the report. Given the correction, Honorable Bartlett?
No, Chair, I moved for, I have a problem with my voice. I moved for the adoption of the report, Chair, sorry.
Thank you, Honorable Bartlett and Honorable Dodovo. Yes, seconded. Okay, Honorable Dodovo? Okay.
No,
Your
Chairman, my
second-
hand is not up. It's okay. It was
I just
up
want
that time.
to record your secondment of the report.
Oh,
with that.
yes. Yes,
Okay.
yes. Second.
Thank you very much, honorable members. The report is, are there any abstentions or objections?
Yes,
Honorable Kalaki?
we abstain at this stage. Thank you.
Okay. Thank you, Honorable Kalaki. Thank you, honorable members. The report is duly adopted. I think we will then go on to the IPID report. Gershon? Once again, our members will go to the recommendation. Okay, 6.1, members acknowledge the financial challenges faced by IPID. However, members recommended that despite these challenges, IPID should find proactive mechanisms to ensure that all cases are investigated effectively. The department should find innovative ways to strengthen its reach within provinces to ensure that it continues to fulfill its mandate. The department should speed up its implementation of the Farnham Commission of Inquiry recommendations in order to improve the efficacy of its work. The department should continue with regular provincial engagements with SAPS, CSP, and the NPA to ensure compliance with its recommendations and to find mechanisms to ensure that the majority of its cases are prosecuted and disciplinary measures are being implemented. The department should continue making the necessary policy recommendations to SAPS to improve and instill a culture of adherence to human rights principles by police officials. The department is encouraged to work hard towards achieving the targets set for the implementation of the gender-based violence and youth development strategy, as these strategies are critical in the fight against gender-based violence, femicide, and youth development in South Africa. The department must prioritize the filling of vacancies of investigations across all provinces to increase the investigative capacity within the department. On members, also the recommendations, are there any comments and or additions that you would want to make? If I can get an indication, if not, can I then get a mover for the adoption of the report?
Chairperson.
Is Dodo here?
Honorable Dodo?
Yes, I do. Chairperson, move for the adoption of the report.
Thank you, Honorable Dodo.
All the recommendations.
I second, Chair.
Thank you, Honorable Mukosi. I see Honorable Mtekwa, your hand is up, but okay. Are there any abstentions and or objections to the report?
Chair, the DA wishes
Honorable
to abstain at this point.
Okay, thank you. All members, the report is duly adopted. We'll then go to the third report on the Civilian Secretariat for Police. Kishan, once again, if you could go to the recommendations. Okay, the department should ensure that despite budget cuts, it finds innovative ways to fulfill its function, mandate and work towards achieving the targets in its APP. The committee requested the department to furnish the committee with the deviation report as well as other research documents in order for the committee to be kept abreast of research findings and recommendations within 30 days of the adoption of the report by the committee. The committee welcomed the suggestions that a presentation would be made on such findings to the committee. 6.3, Gershwin, the department should continue to strengthen its efforts to monitor the implementation of the Domestic Violence Act as police stations, particularly in rural police stations. The department should ensure that all police officials are treating victims of domestic violence with dignity and integrity. The department should include the NPA in its consultative forum meetings to ensure the least amount of cases are withdrawn by the NPA and to further enhance its working relationship with the NPA. The department should develop and implement working protocols with provincial secretaries to streamline the roles and functions clearly. The department should work towards improving its ICT infrastructure to ensure that its services are accessible in all provinces, including those in rural areas. The department should, within 90 days of the adoption of the report by the committee, furnish the committee with a status report on the functioning and resource challenges that exist within the provincial CPS structures. Okay, honourable members, those are the recommendations. Are there any comments and or additions you would want to make?
Honorable Chair, I think, Chair,
Honourable Bartlett?
there's a correction. You said 90 days and it reflects 30 days.
Did I say that?
Yeah,
Okay.
you said 90 days.
But it's 30 days in the report. No? I just read it wrong.
It's 30 days in the report, yes.
That's fine.
Okay.
Thanks, honourable members. If you're happy with the report, is there any mover for the adoption?
I move, Chair.
Thank you, Honourable Bartlett. Any seconder? Honourable Mtetwa?
Yes, Chair, I second it.
Thank you, Honourable Mtetwa. Are there any abstentions, objections?
Yes.
Honourable
Chair,
Mikolaki?
the wishes to abstain at this point. Thank you.
Thank you very much. Honourable members, the report is thus duly adopted. And thank you very much, honourable members. We'll then move on to the final agenda item, which is the report on the Constitutional Court judges and magistrates' salary remuneration. I think we'll deal first with the Constitutional Court judges and judges' salary. Our members, the report is, in terms of these kind of issues, the reports are relatively short. The report is reflected on the screen and indicates that the Select Committee on Security and Justice on the 26th of May received a briefing on the draft notice on the determination of remuneration. The Select Committee, having considered the draft notice on the determination of remuneration submitted in terms of Section 2, subsection 3A of the Judges' Remuneration and Conditions of Employment Act 2001, determining the rate at which salaries are payable to Constitutional Court judges and judges annually with effect from the 1st of April 2020, referred to it on the 29th of April 2021, recommends that the Council approve the draft notice on the determination of remuneration as tabled. That, honourable members, is our report as it relates to the Constitutional Court judges and judges. If there are any comments members would like to make, you're welcome to raise it. If members are happy with the report, if you could then perhaps move for the adoption of the report. Our members, if you have no comments to make,
Nothing, Chair.
are you moving, Honourable Bartlett, for the adoption?
Yes, Chair.
Okay, is there any seconder?
Mtetwa second, Chair.
Thank you, Honourable Tetra. Members, any abstentions and objections and or objections? Honourable Mazamai? Mazamai, I didn't hear what you said. My apologies. Are you seconding?
Yes, Chair, he is seconding.
Yes, okay. No, thank you very much. There are no abstentions and no objections. The report is duly adopted. We'll then deal with the remuneration of magistrates, Gershwin. Members, I'll just go to the gist of the matter that we received a briefing on the 26th of May 2021, and having considered the draft notice on the determination of remuneration in terms of Section 12, subsection 3 of the Magistrates Act 1993, determining the rates at which salaries are payable to magistrates annually with effect from the 1st of April 2020, referred to it on the 29th of April 2021, recommends that the Council approve the draft notice on the determination of remuneration as tabled. On members, if you have any comments, please raise them. If not, and you're okay or happy with the report, then we can then get a mover for the adoption of the report. On members?
Chair, I don't know where the other members. It seems that I must move again, Chair, because there's nothing that we can say except for accepting the report.
Okay, thank you, Honourable Bartlett. Honourable Mtetwa?
Yes, Chair.
I second it, Chair.
Okay. Okay, Honourable Mtetwa seconded, Honourable Dodovo, if you were going to do that. But thank you very much, all members. Any objections and abstentions? Okay, if none, then the report is also duly adopted. Our members, I think we've come to the end of our agenda. Let me just take this opportunity as well to thank you for your presence and participation in this meeting. And let me therefore declare this meeting closed. Thank you very much, honorable members.
Thank you very much, Chairperson.
Thank you very much, Honorable Chair.
Thanks, Chair.
Thanks, colleagues.
Recording stop.